This is Michael Popok, but look at the time. It's time for Legal AF After Dark. Judge Juan Merchan of the Supreme Court in New York is about to sentence Donald Trump for 34 felony count conviction September the 18th. Or is he? Is there an immunity issue in play about the type and quantity of evidence that was presented against Donald Trump during the trial? Should that matter? Will that matter? What will the judge do on the 16th of September when he rules on immunity and whether any aspect of the evidence that was presented should have been barred, should have been prevented from being presented? And would that have affected the outcome of the jury verdict or not? And then 2 days later, sentencing. Or will the appellate court step in off of some sort of appeal by Donald Trump and stop the sentencing? We break it all down for you on Legal AF. Take a listen. And let's turn to the Manhattan DA because there were some developments there related to the sentencing. Now, let me just frame it quick. Unless there's a change and the judge decides to make a change, he's already ruled and amended his order once. September the 18th, he's going to be sentencing, unless on September 16th, 2 days later, he finds any valor or merit to Donald Trump's argument that certain of the evidence that came into the jury would have been outcome determinative, but should have been barred under the immunity decision by the United States Supreme Court because it dealt with official conduct. That's the complicated way of saying what aspect of the immunity decision maps on to the jury's findings in terms of their deliberations and the evidence presented. So the judge said, I'm going to rule on that on the 16th. He already moved that date once. 2 days later, if there's still a case around, wink, wink, I'm going to do sentencing. So you better send your confidential sentencing memos in, which are generally sealed on the docket. Take it from there, Karen. Filing by the Trump, filing by a Manhattan DA, and then we can all spitball. What do we think happens next?
Yeah, so what happened is Trump asked for a delay as usual, and that was expected because his whole playbook is delay, delay, delay. So I don't think that surprised anybody that they requested a delay of sentencing. And, they also put in a motion in their request for sentencing, they also said for the fourth time, they asked that Judge Merchan be recused. And then they said, they made up all these reasons claiming why this was new, et cetera. And the judge very swiftly said, I'm not recusing. You've asked me 3 times, and I've got an advisory opinion from the judicial ethics people. I looked in my heart and seen that this is not, I don't need to recuse. I'm going to be fair and impartial. And the record is going to show that he was fair and impartial as well. That's going to be clear. All the rulings on appellate reviews. So he smacked that down very quickly, but there's still the immunity assessment that has to be done in the case, right? That he still has to go through the motions of applying this new law, this new judicially created law that the Supreme Court created, this presidential immunity, this absolute immunity from criminal prosecution, something that no other human in the United States of America is afforded, this absolute immunity from criminal prosecution if it falls within one of your core presidential duties. What I don't understand is how committing a crime can ever be part of your job and part of your core duties. To me, the minute you commit a crime, you have done something that isn't within your core presidential duties, but somehow they have created this brand new judicially created law. It's not in the Constitution. It's not created by the Senate and the House of Representatives and then signed into law by the president, the way most statutes and laws are done. This doesn't appear in case law. This is something that they truly made up. They even went beyond what the parties asked for. They went beyond it, and they ruled not only is a president immune, absolutely immune from any prosecution. Well, they said federal prosecution, but for any criminal prosecution if they're acting within their core presidential duties. And that is going to impact the Washington, D.C. case, certainly. But how will it impact the Manhattan DA's case, since that conduct was entirely personal, right? That conduct involved paying off hush money to a porn star in order to hide that from the American people, so that the American people would not know that information before the election. And he had his fixer, Michael Cohen, fix the books and records and write checks to do this in order to make it look like it's legal fees when it was actually not legal fees. They grossed up the amounts, they lied and for something else, and they created like a business fraud, essentially, and it was personal. So why does this new law impact this case? And that's because the other thing the United States Supreme Court did was they created this new standard that evidence you can't use evidence of things that were within the core presidential, while he was president. You can't use any evidence that would fall within this presidential duties type conduct in prosecuting non-immune crimes. And so the question is, does any of the evidence that the Manhattan DA's office introduced fall into that category? We've discussed many times that there are a few things that the judge is going to have to make a determination on. Some things clearly not, but some things might, like Hope Hicks, who worked at the White House at the time. Is that going to be evidence that should not have been admitted given this new ruling? And so the judge has to rule on that, and we expect that to come on September 16th. And that's going to be kind of a big deal. So why are we here today? What are we talking about? Well, the question is, if the sentencing is September 18th, can you have a sentencing September 18th if the judge is going to rule on this immunity question 2 days before? And the Manhattan DA's office wrote a letter that essentially signaled to the judge that they believe that the sentencing 2 days after that ruling may not be feasible. And they explained why. Now, rather than coming out and saying that, what they did was they said, we defer to you, Judge. You do what you think is right. We're not going to take a position about that. And that is in some ways signaling to the court that they're not going to object, and that they see that there might be a valid reason to do that. And some people were not happy about the Manhattan DA's office taking that position, saying, no, they should demand sentencing. Why aren't they demanding sentencing? And what I say to those people is, this just goes to show you that Donald Trump is not correct. In fact, he's absolutely wrong when he accuses the Manhattan DA's office of political persecution. And I worked there for 30 years. I know those people. I know what they do. They don't do that. They call balls and strikes as they see them. It is an adversarial process, but they don't push for things they don't believe in or that they think the law doesn't say. It's just not like that. And they don't look at politics. They are not thinking about what this is going to do because he's, running for president and was a former president. They're looking at this coldly, objectively, and what if he was any other defendant? They've been saying all along he should be treated like he was any other defendant. We've all been saying that. And this is one way they are saying they are the most fair, honorable, honest office. And that is my experience there. And that's what this letter showed, because the letter essentially says to the judge from them, it essentially says, look, Judge, it's unclear whether he can appeal your ruling on this issue about whether immunity applies to the evidence in this case. And why is that? Because if it was about presidential immunity, if it was about the decisions on the does this fall within the core presidential distinction or not, that is appealable midstream before sentence. You can do an interlocutory intermediate appeal. There's only a very small category of things that you can do that with, by the way. Normally you have to wait until after conviction, after sentencing, and then you can appeal like any other normal defendant. But sometimes you can appeal before that. You can appeal in the middle or during the case. And this is one of those times where they are saying, we are not sure. We know that they can do it if this was about the presidential immunity decision. But and if it's about one of the charges and would the charges be immune, that you can appeal in the intermediate step. Can you do it with the evidence too? They said, we're not really sure. And the Supreme Court, the decision that they handed down on July 1st, it's unclear. It's silent as to that. And so what will the appellate courts do? Is this enough time to go to the appellate courts, the 2 days between the 16th and the 18th? Is that enough time to brief it? Will they stay it? And so they raised the questions in this letter, and they said essentially to the court, look, this is a tough, they're essentially saying to the court, this is a tough one. The law's not clear. We understand if you have to do it, and we defer to you, Judge, you'll make the right decision. And that's what they did. And I give them a lot of credit for it. It's hard to do that, but that's what you have to do as a prosecutor. You prosecute cases without fear or favor, and you call it like you see it, and let the chips fall where they may. And it frustrates me, and always has frustrated me when the prosecutors at that office, I can't talk about all prosecutors, but in that office, when we used to get accused of playing politics or, what are they doing? And are they doing this in order to, it's all political? It's not. It's just not. That's not how the office works. And this, to me, is yet another example of that. And we'll see what the judge does. But I think it's 50-50 whether the sentence goes forward on the 18th or not. The judge might say, look, this is going to get appealed either way, so let's just go forward and do the sentencing. Part of me, it depends on the day of the week or the hour of the day, and I'll let you know if, where I fall. Right this minute, I'm thinking he'll probably go ahead with the sentencing anyway on the 18th and just let them appeal. But then there are other times when I look at it and I think, I'm not really sure. He's not, he knows that any sentence is going to get stayed anyway pending appeal, because there are some pretty legitimate appellate issues, here, including the one that we just talked about, that are not frivolous. So he might say, look, since we know it's going to go up on appeal anyway, and he's not going to go into jail or prison, let's put off sentencing and let's appeal it midway. So it depends. It could go either way. It's 50-50 for me right now on whether he gets sentenced on the 18th.
Well, Dina, you mind if I go first?
I'll go for it.
Okay. People like when I debate Karen. I don't see it as that tough of a call. I think the judge is going to go forward on sentencing. The judge understood how a calendar works. He knew that the 16th was only 2 days away from the 18th. He knew that Donald Trump had been threatening to bring some sort of appeal. I think that's the way I read that letter. I thought that your old office did two things very smartly. One, one on the appeal issue. Donald Trump always threatens appeals, federal appeals, state appeals. They mischaracterized the nature of the appeal. They said it was an immunity decision that would divest the court of its jurisdiction, which is true if that's what the issue was for this particular appeal. But they've already admitted and conceded in prior filings that they're not bringing a Donald Trump is immune from prosecution argument. They're bringing the evidence argument that you outlined there, meaning that it's just about whether a couple of pieces of evidence should or should not have come in to the jury or not, because they did or did not fall into official conduct or not. And so that's an evidentiary issue, not an immunity divesting the court of jurisdiction issue. And the Manhattan DA smartly called that out in their filing by saying that's not the right immunity that you're talking about. And so you can try to do your appeal, go ahead. It's almost like inviting them to make a bogus, a wrongly framed appeal, have at it. And I think what they're asking the judge to do, while appearing to be neutral and agnostic, is to say, because they dropped a footnote on this, they said, Judge, you know how the calendar works. You knew the 16th and the 18th were only 2 days apart. In other words, let the appellate court, if and when they threaten lots of things, Judge. They threaten to take all sorts of motions for orders for contempt up to the appeals and gag orders, and they multiply bring motions about your recusal. They're not saying this. This is my interpretation. They bring things about your gag order, or they don't. Let them do whatever they're going to do. And if the appellate court thinks that the issue's been properly framed and has an element of it that deserves on the merits, that there's a likelihood of success on the merit, to stay the case, let that stay come from the appellate department, the first department appellate division in Manhattan. or from some federal appellate court if he was able to do it, but not from you. Let them do it. And you go forward right now on the 18th. And that is what every litigant generally gets. I know you're big, Karen, on treating this guy like any common two-bit criminal that he is. And I believe that. And any common two-bit criminal would get the entirety of the appeal, because you can't do piecemeal appeal. The appeal has to be on what happened during the trial in its entirety, all the things that happened during the trial that they had problems with, from the recusal of the judge, the disqualification issue on the judge, to the evidence that was brought in, to Michael Cohen's testimony, to this, that, and the other thing. Whatever you got one shot at appeal all in one place. And your sentencing, whatever your sentence is, you don't get, for those that just follow us casually, you don't get separate appeals on all these component parts. Oh, an appeal on your sentence, and unless you just want to appeal your sentence. But you can't have multiple items. You have to do an omnibus appeal about everything that you think happened that merits a reversible error or reversing or vacating of the sentence, of the judgment and the sentence. And so there's my interpretation was, let him bring whatever appeals he's going to bring. We'll stay neutral, Judge. You know what to do. Let the appellate court do their work. And if they want to stay after he's properly framed something, because he can't even get right in the letter that he wrote to the court what the nature of the immunity is that he's alleging. So let's see what he does at the appellate level. And then they can always enter a stay. But why should you? Now, I'm grafting a lot of my own interpretation of this on it. And that's how I read it. And so I think he goes forward on the 18th, because it's not by accident that he made 16th and 18th. He could have had them a month apart, because there's no amount of time really to allow for a complete briefing. It's always going to have to be an emergency application and appeal with expedited briefing granted by the appellate court, because there's just no time. Otherwise, he'd have to put a gap of 6 months to a year between the sentence and the decision on immunity. And he's never going to do that. He's got an obligation under the criminal procedure law of New York to enter a sentence quickly, expeditiously, unless there's, and the grounds that they cited under CPL 330 for why, which is one of the statutes here, as to why they're entitled to a delay, none of it fits. None of it is applicable. So they're wrong on the law, they're wrong on the procedure, they're wrong on the facts, they're wrong on the immunity doctrine. So why give them any benefit? Go forward on the 18th and let the appellate court sort it out. That's where I'm at, Karen.
Yeah, like I hear you. I just know the office, and I can tell you right now, the first draft of this, and I don't know this from firsthand knowledge. I know this because I know how they work. The first draft of this said we consent, like we agree there should, this is essentially them signaling to the court that they think that probably should not sentence him on the 18th. That's what this letter said. Whether
Wouldn't
the judge
permanently delay the appeal? If you don't sentence, then you leave open-ended the appeal by Donald Trump.
Yep. Yeah.
So why would you want to leave open the appeal?
Then you could only appeal the immunity part of it. That's what you could do. That's the only thing you'd be able to do is appeal that midstream. That's the appeal that they would do right away. But that's what they're essentially saying in this letter is basically, Judge, I think you should, because this is why they're doing it this way. If the judge gets it wrong, the conviction gets overturned, and they don't want to retry this. So they are saying, okay, this is such an important decision that this judge is going to make. The judge is going to have to decide, is the Hope Hicks testimony that Josh Steinglass, the DA, in his summation said is you don't have to listen to Michael Cohen if you don't think he's credible because everything is corroborated. This is so important, this Hope Hicks testimony. And he really, really underscored that. The DA's office is acknowledging that decision, if the judge rules that this was wrong, that you shouldn't have allowed that in, but it was harmless error, and so therefore the conviction stands. If that's what Judge Merchan finds, that decision is so important that I think they don't want this to be overturned. And so after sentence, that's the only remedy. The case is not over yet. I mean, yes, it's already been a verdict, and the jury's already reached a verdict. But I think this is such an important, critical thing that they are acknowledging that the judge might need to allow the appellate courts to weigh in.
And procedurally, because you think immunity is involved, they could take a separate appeal just on immunity and not on the conviction, or just you got to bring it all, don't you?
Well, the Supreme Court said in their decision that the immunity piece you can appeal midstream. So, for example, we know that the Washington D.C. case that will be appealed, unless Tanya Chutkan, dismisses that entire case. Or if they supersede it with a new indictment that's clearly has nothing to do with it. But that is appealable, in the middle of the case. When you do an interlocutory appeal, you can only bring the issues that fit within that narrow category of an interlocutory appeal. So, but it was silent as to whether the evidence, the evidentiary immunity is also you can also appeal that interlocutorily. And I think as a result, the DA's office is hedging a little bit and saying, maybe it is, maybe it's not. Anyway, Dina, what do you think about all this?
Just jumping. I mean, immunity is always interlocutory because the idea is you are not supposed to be prosecuted. And if you go through the whole trial, you've got this adverse effect to you that can't be undone. But in terms of the idea of like it being harmless error and reversing a conviction, I mean, that can happen all the time on an appeal. So I think, the judge seemed to me like really clear that he thought this was not having to do with his official capacity. The immunity issue essentially was raised a lot earlier because his idea was that this was official and not personal. And so I think that he might be able to really distinctly see that this is more about the evidence. There is going to be a bunch of things around the evidence, whether or not Stormy Daniels' testimony wasn't too broad. I mean, that can get reversed also for the same reason. He could see that wasn't harmless error. So I think if the judge hadn't already looked so much at the immunity issue and made a decision around that, then maybe this would be a little bit of a different conversation. But because he already essentially did that, I think the Supreme Court's direction is not necessarily saying that the evidence issue goes into the immunity issue, but that they're kind of introducing like another evidentiary rule, like another rule like hearsay. It's yes, if you introduce evidence that came about because of immune things, then that is not allowed to be introduced. But I see those as two separate things.
Well,
I agree with Karen. I agree with Karen, though. It is silent in the July decision. Immunity in general, if you're prosecuted for something that you should have been immune from, that has to be done up front, and that can be interlocutory. But that open question is a good one that Karen framed, which is what do you do with the evidentiary part of it, which is the one we all smacked our head over when we saw. We're like, what do you mean the evidence of official conduct can't be used to show unofficial conduct and prosecutes? And that's the gray area that Karen outlined. I agree with. I still think he goes forward on the 18th with the sentencing, knowing that he only had 2 days in between, and let the appellate court do whatever they're going to do. And if the appellate court finds it interesting, they know how to issue an injunction, and they know how to stay a case, and they can do it. It takes Mershon out of it. It takes the Manhattan DA's office out of it because they've already said we're neutral. And all of that. Welcome back. We sit at that intersection of law and politics so you don't have to. We do it every Wednesday and Saturday at 8 p.m. Eastern Time on a show we named 4.5 years ago, Legal AF. There it is. And now you know why. And if you don't know why, join us. Watch the live recording and participate in the live chat Wednesdays, Saturdays, 8 p.m. Eastern Time. Or you can pick it up everywhere you get your audio podcast from, and any audio podcast platform. Just plug in Legal AF. We curate the top 5 stories at the intersection of law and politics. We bring it to you just like that. On Wednesdays, it's Karen Friedman, Agnifilo, and me. On Saturdays, it's Ben Mysalis and me. And then we do hot takes like this about every hour on the Legal AF and MeidasTouch network. So until my next hot take, until my next Legal AF, this is Michael Popok, and I'm reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.